Afternoon. I hope everybody can see me online. Thank you very much for joining us for today's webinar, AI and Access to Justice, Promise, Pitfalls, and Practice, part of the 2025 Access to Justice Week series of events in Manitoba. My name is John Burchell, Executive Director, Manitoba Law Reform Commission, and I'll be your moderator today. Today's event is being hosted on Treaty 1 territory, original lands of the Anishinaabe, Cree, Oji, Cree, Dakota, and Dene peoples, and the homeland of the Métis Nation. Additionally, I'd like to recognize that Winnipeg's water originates from Shoal Lake, situated in Treaty 3 territory and the home of Shoal Lake 40 Nation. We are pleased to welcome participants from locations in the different treaty territories across Manitoba. The Law Society is committed to continuing the ongoing journey towards reconciliation with Indigenous peoples. I would also like to recognize our partner organizations for Access to Justice Week, the University of Manitoba and the Manitoba Bar Association. We're scheduled for about 1 hour and 30 minutes today. Audience questions will be welcome. To submit a question, use the Q&A function located on the bottom of your Zoom window. To avoid speaking on topics that may be overlapping with subsequent speakers, questions will be held until the end of presentations. A chat function will be used to report technical issues, but it will not be monitored for questions. Today's speakers are Dr. Katie Szilagyi, Assistant Professor, University of Manitoba, Faculty of Law, Elisa Schachter, Director of Policy and Strategic Initiatives at the Law Society of Manitoba, Mary Trosco, Executive Director, Community Legal Education Association, and Susie Dunn, Associate Professor Dalhousie, or Assistant Professor, Dalhousie University Faculty of Law. In the interest of time, complete bios of all our speakers, you can refer to the University of Manitoba's Access to Justice website, which is the same place you registered for the webinar. Now I know Dr. Szilagyi has some slides, and I would just like to turn the floor over to her as our first speaker.
All right. Thank you very much, John, for the introduction. Looking forward to our conversation today. I'm just going to share my screen. Perfect. Look good, everyone? So I'm starting us off today with some introductory information about how generative AI works. And I do a lot of teaching, research, and public education on the topic of artificial intelligence. And I find that we get a lot of questions about what that term actually means in practice. What does it mean for something to be artificially intelligent? How does it exhibit human-like characteristics when we have computer programs that have various skills? And there are a lot of different types of applications that one might say constitute AI. And in fact, depending on how broadly one draws the definition, it can include very ordinary or run-of-the-mill activities, right? Things like your Grammarly or your Antidote that are used to improve language. How about Google Translate or DeepL to do translation services? Your more prototypical examples of generative AI, things like ChatGPT, DeepSeek, Copilot, right? Things that are working in tandem with you as a word processor to come up with human-like outputs. We also have your image generators, things like Midjourney, Firefly, built in increasingly into the big Gen AI generators, or new technologies like Sora 2, released recently by OpenAI, that allow people to create really convincing videos and deepfakes. But when we're talking about something that exhibits artificial intelligence, we want to really focus in on machines that have the capability to learn, right? What does it mean for a machine to get better over time at doing a particular task? And today's conversation is really just about generative AI, this specific sub-application of a larger ambit of what AI might do. The technology that powers generative AI is called a large language model. You may have heard this described as an LLM. And your big example of an LLM is ChatGPT, right? ChatGPT has a user-friendly interface. It wants to ask you questions. It wants to engage with you almost in a conversational way. There is something really anthropomorphized about the way that ChatGPT was defined, in that it has that little ... when you're texting back and forth with it, right? A design choice to make you feel like you're talking to a human on the other end. And as a chatbot, ChatGPT can be very helpful, right? It can be very convincing. And it has a lot of fellow travelers, things like Google's Gemini, things like Copilot, which has the ChatGPT infrastructure built in on the back end, things like Anthropic's Claude, and a lot of other in-house large language models that are purpose-built for specific applications, many of which are now legal applications. We know that, we see here on the bottom of the screen, ChatGPT can make mistakes. Consider checking important information, read our terms, and apply privacy policy. But how do these things really work? When we talk about ChatGPT, I want us to focus in on those last three letters, GPT. GPT stands for a generative pre-trained transformer. And what that means is that's the chief innovation that the large language model reveals. It's generative in that it's going to create new output in response to human inputs. It's pre-trained in that it specifically received a lot of training on how language works in the background processes that allow it to excel at something called zero-shot learning. What that means is when you first interact with a large language model, it's really good at coming up with an effective output in response to your very first question. You don't have to train it in that prototypical machine learning environment where something's really quite bad the first couple times out and it gets more powerful over time as it's given more examples. ChatGPT has received background training and it knows how to deal with language in advance. And T is transformer, and that refers to the mathematical machinations going on in the background that is converting text into mathematics, and in particular, a probabilistic likelihood of what word is most likely to come next in a sentence. So if we think about how structural linguists might describe language, they would distinguish between two different main types. What does language do? Well, there's langue and there's parole. Langue is grammar, and this refers to the rules that we use in order to generate sentences. There's a finite number of these, right? There's only so many. It might seem like English has an exception to every rule, but there are theoretically only so many rules about how the language works, and those are collectively held by everyone. Everyone uses language to communicate in relatively the same way. And that's distinguished from parole, or discourse, right? These are the observed instances of sentences. How are people using language to communicate something that is infinite, something that is individual to them, something that is unique in the way that they want to express themselves and convey meaning? And when we think about a natural language processor, you'll also see that NLP, another acronym to refer to an LLM. NLPs are focused on reproducing grammars. What they're trying to do is make sure that they know how language works. In order to do that, they have been exposed to a huge repository of examples. And this is drawn from the internet through a process called text mining. So web crawling bots have gone and amalgamated huge, huge amounts of text, trillions and trillions of bytes, to see how can we have a lot of examples of how language works in order to learn from. Right? The original ChatGPT that was released in November of 2022, that's the ChatGPT 3.5 model, was trained on something called the Books Corpus 2 dataset, and it contains lots and lots of old books that are no longer copyrighted, lots of content from Wikipedia and web pages, and a lot of social media posts, including Reddit, right? Information that just says, how are people using language when they talk to one another? And in that, it builds a probabilistic model of how likely some word is to come next in a series of sentences. Now, importantly, this is just an approximation of language, right? It isn't exactly the same as thinking about how meaning is conveyed traditionally. You can think of it almost like a linear regression, right? A mathematical approximation of a bunch of data points. Some of them are going to be really close to the line, and some of them are going to be a bit further away. So in an LLM process, it begins with a process called tokenization. And what that means is that the input text, so the string of text that you input into ChatGPT, is converted into tokens. And that means that the LLM is not experiencing words as words, but rather as words as tokens, right? Subsets of words. This is why early LLMs were really bad at something called the strawberry problem. If you asked an LLM how many instances of the letter R are in the word strawberry, should be 3, right? Strawberry. But it could never tell you that. It would only ever say 2 at most, because it was probably just looking at berry, right? Half the word, because the word had been chopped in half in order to be dealt with as a token. More recent versions of LLMs have fixed this problem, but it's actually just they've scaffolded on a solution so that when people ask that question, they don't get a wrong answer anymore. So then the tokens are transformed into vectors through a process called embedding. And what that means is they're converting it into a complex mathematics that is then contextualized, right? These transformers have to be changed based on the surrounding tokens. What was the other information that was input into the context window? How is the information being used in context? How do we want to represent it? And then finally, a generation process occurs where contextualized embeddings are passed into a predictive model. That means that there's going to be a little table generated in the background that says, how likely is it that a word is going to come next in a series of tokens? And based on the weights that are probabilistically assigned to those tokens, they can do that computation. Now, really importantly, they don't necessarily just give you the top result every time because of a variable called temperature. And what this means is that there's some creativity, some flexibility in the ways that LLMs come up with their solutions. It's why LLMs are so good at emulating the experience of talking to a human chatbot online. But it's also why we have this thorny problem called hallucination, where sometimes LLMs will give you something that's just out of left field. So I hope that that's a good introduction to how this stuff works. That's my 10 minutes. So I'm going to stop sharing right now and turn it over to our next speaker. But I'll be happy to elaborate further on these conversations in our question period and later on in the group discussion. Thank you.
Thank you very much, Katie. That was an excellent presentation. And our next speaker is Alicia Schachter. Welcome, Alicia.
Thank you very much. Good afternoon. It's great to be here. And I enjoyed your presentation, Katie. I learned a few new things, so that was great. I am with the Law Society of Manitoba, as John mentioned. So I'm going to focus my remarks on lawyers' responsibilities and obligations when using AI, because we are, of course, the regulator of the legal profession, and we regulate lawyers in the public interest. I would say, I know there might be some students online today, as well as some members of the public, and I think this is still relevant to you for the students. you will blink and you will be a practicing lawyer. So you will need to kind of understand this perspective, and using AI as an articling student or a lawyer is a bit different than using it as a student. And if you're a member of the public and if you're self-representing, then I would suggest that this is relevant as well to you. You can consider some of my remarks to be best practices. So just a note for those of you that are either articling or new to practice, as I said, keep in mind, you should be thinking about different things if you're going to use AI in practice versus when you were a student. Once you're an articling student and when you're a practicing lawyer, you have professional and ethical obligations that you have to meet, which are set out in our Code of Professional Conduct. And those are really important to keep in mind. So there are well, maybe I'll mention first, in April 2024, the Law Society published guidelines on using generative AI in the practice of law. They're published on our website, so you can find them. Much of what I'm going to talk about today ties back to the Code of Conduct and to lawyers' professional responsibilities. So really important that you're aware of them. Maybe just a couple things before I get into that. It's always really important to understand a certain number of things about the tools that you're using. Some tools are general and will pull information from the internet. And of course, we know not everything there is accurate, whereas other models have been designed specifically for lawyers to use in their practices, including for legal research. And these more bespoke tools will have built-in guardrails to protect against inaccuracies or breaches of confidentiality. So firstly, I'll talk a little bit about one of the duties under the code, and that is the duty of technological competence. Lawyers have a duty to provide legal services to their clients in a competent way, and part of this includes an understanding of technology that's relevant to your practice area and being able to use that technology effectively. It also means understanding both the risks and the benefits of any given technology. So when it comes to generative AI tools, you need to know how the tool works before you start to use it. And I think Katie referenced reading the terms of service, so you understand what the tool itself will do with any data you input. It's also important to think about and be careful and specific with the prompts that you give AI, because of course the results you get will only be as good as the prompts that you feed it. Really, really important to review and validate the information that the AI tool is providing. If you use the tool for legal research, look up the cases it identifies. This is something that's been reported on, I think, fairly widely, hallucinated cases that lawyers have relied on. And yet I think we still continue to see instances of lawyers or members of the public relying on AI to do some legal research without verifying the results. Something else to keep in mind is that some AI tools will use static data sets. So the information that it generates for you will only be as current as that data set. And in other words, it might be out of date. So that's something to check. And I talked about hallucinations. So, I think we're increasingly seeing the way that AI really wants to please us. So if it can't find the answer to a question that we have, it will often make things up. And it might do this in a way that's really convincing. The text is quite articulate, and the grammar, of course, is impeccable often. So you've got to just be alert to that. Another duty under the code that touches on AI is confidentiality. Lawyers, of course, have a duty of confidentiality under the code. And this issue intersects with AI because client confidentiality or client privilege might be lost if you're not alive to the way in which your information is used. So you need to know whether the information that you're entering, including any documents you might upload or any queries you enter, will they be used to train the AI? Some will do this, and the information could be shared with third parties. Other AI platforms will have robust data security built in. So this is really important to understand. There might be situations where you can anonymize client information and enter it into AI, but if you're at all unsure about potential breaches of confidentiality or privilege, get your client's consent before you use the tool and clearly communicate how you plan to use it and what the potential risks are. Like any other IT product or service, you should think about whether the tool itself is secure, and it is worth, if you're a lawyer working in a firm or an organization with IT staff, it's really important to talk to them about it. If you're either on your own or if you're at a smaller firm, there might be an IT or cybersecurity consultant you've had occasion to help you out with other issues, and it would be worth speaking with them. Increasingly, applications are embedding AI features into them. So, for example, we use, as many do, we use Adobe in our office a fair bit, and we recently discovered that it has now built in an AI function. And I don't believe we were given any sort of formal notification of this. We just noticed that it was suddenly there. So, this raises a series of questions, like, is it a closed loop of information? What happens to the documents that we might upload to Adobe? So again, these are all questions we all need to be thinking about and spending some time looking into. Discrimination and harassment, as you probably all know, are prohibited by the Code of Conduct for Lawyers and, of course, human rights legislation. And generative AI might be trained on biased information. So the work product that it would then produce would then duplicate or replicate that bias or discrimination. So this is something else to be mindful of. Under the Code of Conduct, lawyers have the responsibility to directly supervise anyone that we delegate work to. So if you delegate work to a student, a junior lawyer, an assistant, you have to supervise that work and you are ultimately responsible for it. So AI really needs to be treated in the exact same way. You wouldn't file a brief that an articling student drafted without reviewing it, or at least I hope you wouldn't. So you shouldn't be relying on research or other work product generated by AI without ensuring that it's accurate. And again, this might sound obvious and it's something you've probably heard, but it bears repeating because we continue to see these mistakes being made when people are in a hurry and looking to take shortcuts rather. I mentioned sort of, cases in the media that have reported on instances where cases are used or relied upon by lawyers that are hallucinations. AI makes them up. So there was an Ontario family law case that came out in the spring, and I thought it would be worth just highlighting it. The case was Ko versus Lee in 2025 Ontario Superior Court 2766, where one of the lawyers filed a factum which contained several citations to cases that had nothing to do with the argument she was making, and a link to a case that did not exist. During oral submissions, the judge asked the lawyer if her factum was prepared by AI, and her reply was that her office doesn't usually do that, but she would have to check with her clerk, which was a troubling answer to the judge. I'll read you an excerpt of the judge's decision. It's the lawyer's duty to use technology to conduct legal research and prepare court documents competently. It is the lawyer's duty to supervise, staff, and review material prepared for her signature. It is the lawyer's duty to ensure human review of materials prepared by non-human technology, such as generative artificial intelligence. The judge went on to write, it should go without saying that it is the lawyer's duty to read cases before submitting them to a court as precedential authorities. At its barest minimum, it is the lawyer's duty not to submit case authorities that do not exist or that stand for the opposite of the lawyer's submission. It is the litigation lawyer's most fundamental duty not to mislead the court. And the judge then went on to order the lawyer to show cause why she should not be cited for contempt. So pretty strong words from the bench and potentially serious consequences for the lawyer, not to mention the reputational damage. So good idea to make sure you've got clear policies in your workplace about what AI might be used for, and to ensure that staff and all lawyers have training on both the practical risks and ethical implications of using AI. Another duty under the Code of Conduct is to treat tribunals with candor and respect. And we can see how in the case that I just talked about, that was an issue when this lawyer relied on AI that they hadn't verified, or cases generated by AI, rather, that they hadn't verified. But this duty under the code to treat tribunals with candor and respect includes guarding against misstating the facts or law, misstating what an authority says, failing to tell the tribunal about a relevant binding authority that the other side hasn't mentioned. So the lawyer in that case might have also found herself in trouble with her Law Society. And I would say that if you find yourself opposite a self-represented litigant on a case, of course, you should check their any cases they rely on, any research they provide. If that individual has used AI, as I think we are seeing self-represented individuals are increasingly doing, understandably, you want to make sure that's accurate as well. And if it is not, you have to bring that to the attention of the court. The Court of King's Bench does have a practice direction on the use of artificial intelligence in court submissions, and it essentially requires that when AI is used in the preparation of materials filed with the court, the materials must indicate how AI was used. So that's a practice direction from the court. As we all know, I mean, AI is a very rapidly developing area. There are changes practically every day that we're seeing, and a variety of different issues that arise, and new laws that are being introduced. We're learning new things about AI and about the nuanced ways that it might lead us astray. If you're in a workplace and there's someone there who's sort of a techie and really has an interest, then it would be great to kind of identify somebody who's responsible for staying up to date on these issues. Someone who has an interest would be great, maybe even you. And they can then share that information with colleagues and others in the office. It is pretty tricky to stay on top of all of the rapid changes. So good to have somebody who, who has an interest in the area and is prepared to dig in. Communication with clients, like anything else, if you plan to use AI in a client matter, you do need to tell them how you plan to use it. Is it just for research? Is it for doing initial drafts of documents? But be transparent and tell them about the benefits and any potential risks, including the risks that I mentioned earlier about breaches of confidentiality and potential loss of privilege. And then, of course, the steps that you're going to take to mitigate those risks. The guidelines that we have mention the use of chatbots. I don't know if there are firms in Manitoba that are using chatbots, but some will do so for client intake. But this is an area you have to be really careful in if you're going to rely on AI for any form of communication with clients, because you want to avoid miscommunication, obviously. Another area that's key, and I think that we've heard some discussion on, kind of broadly, is how AI might affect lawyers' fees. So the Code of Conduct says that a lawyer must not charge a fee or disbursement unless it is fair and reasonable and has been disclosed in a timely fashion. So be transparent with your clients about how the use of AI tools might affect their legal fees, and make sure your clients understand the basis for fees and expenses, including those associated with the use of generative AI. The efficiencies that result from AI should not lead to a windfall for the lawyer. So if using AI saves you a couple of hours on a task, it is not appropriate to charge the client for those couple of hours that you no longer are spending. It is appropriate to charge the client for the time you spent crafting and refining AI prompts, the time you spent reviewing, editing, and confirming the generative AI output. So there definitely are implications, but lawyers need to be careful that they're not seeing this as an opportunity to charge the same amount and save time, because that would be contrary to the code and your obligation. In summary, I think we know that AI is here to stay, whether we like it or not. Some of us are enthusiastic adopters, and others perhaps less so. But I would encourage you to embrace it, to become familiar with it. A good way to start using it is in your personal life. And remember, when you use it professionally, it is not a substitute for your oversight and judgment. Your clients are paying you for that, so make sure you continue to exercise it. And I will end there, and I will be happy to answer any questions later on when everybody's finished. Thank you.
Thank you very much, Letha. And I think you made a really good point there about, while you quoted from the Code of Conduct for lawyers, we have other professions here, other professionals that have codes of conduct and duties and responsibilities you have to your supervisor and other organizations. So I think it's a very broad topic that applies to a number of professions and organizations. That brings us to our next speaker, Mary Trosco, and welcome.
Thank you. Thank you very much for inviting me to be on the panel. I did enjoy the other two presentations. I learned a lot, and I think I'll have to review the first one because it was a lot of new information. My focus is going to be on the general public and self-represented litigants and our experience at Community Legal Education Association with how they're using AI. And also I'm going to talk a little bit about the access to justice crisis. Okay, first of all, I'd like to start by giving you a bit of a background about Community Legal Education Association, or also known as CLEA. We've been around for a while. We celebrate our 40th anniversary this past year. CLEA's biggest program, the Law Phone-In and Lawyer Referral Program, has a history that predates CLEA and is celebrating its 50th anniversary this year. We're a small group. There's only 7 of us in terms of staff. And as I mentioned, the Law Phone-In program, CLEA's largest program, it's staffed by 2 lawyers. They provide legal information, summary advice, refer people to various law-related and other resources. In appropriate cases, they can refer clients to one of the over 100 lawyers in our lawyer referral panel. In that case, the first interview with that lawyer, lasting up to half an hour, is free. On average, the Law Phone-In program handles between 8,000 and 9,000 calls per year. The total calls during Law Phone-In's 50 years of existence is nearly 450,000. In terms of other programs, our program coordinator arranges presentations for various groups and also arranges speakers for webinars in the fall and spring every year. CLEA has an inventory of over 100 plain language publications, a website with over 500 frequently asked questions, and those are based on inquiries through Law Phone-In, an online course, and over 90 videos on a variety of legal topics. CLEA also operates an intimate partnered violence project and a workplace sexual harassment project. Now, we all know that we're in the middle of an access to justice crisis. It's going to get worse. I'd like to explain how we see that from our perspective. Too often when I hear people talking about access to justice, they're only referring to access to lawyers and courts. And lawyers and courts certainly play a role, but they're not the only solution. In some areas of law, for example, family law, we're finding there are too few lawyers. Even though legal aid has increased its financial guidelines, there's still an ever-growing gap of people who fall between being able to afford a lawyer and legal aid's guidelines. What we need to look at is some non-court solutions. And if we had more of these, maybe people would rely on AI less. I don't know. That includes access to public legal education and information like we provide at CLEA. It also includes services like those provided by the Family Resolution Service, for example, administrative solutions through Maintenance Enforcement, the Child Support Calculation Service. Too often, we're being told by people calling us that the government departments are falling short of and not helping. They're just instead telling them to hire a lawyer. A good example of some of the ways that happens was the recent article about CRA. And when you make an inquiry there, if you're asking about your own personal taxes, the accuracy rate is not great. In any event, departments like Consumer Protection, Employment Standards, Resident Chances Branch, I think can all go a long way to helping in resolving some of the access to justice issues. It also should not come as a surprise that we at CLEA are dealing with more and more unrepresented and self-represented litigants. Even though sometimes it's hard to get exact numbers or percentages, we can all agree that their numbers are growing. If we see the same pattern here as in the US taking place, we can expect numbers as high as 80%. We should also remember that often self-represented litigants, they're not there because they want to be. They're there because they have no choice. And I think this chart sort of speaks for itself. We've gone from 188 unrepresented litigants in 2019 to 1281 in 2023, 1,133 in 2024, and this year we're again looking at over 1,000. It should also come as no surprise that with the access to justice barriers that they're encountering, the general public and unrepresented litigants are turning to AI. They use it for legal research. We found that they are using AI for information about the court system as well, or court process. Unlike lawyers who know how to do legal research, the general public does not. Lawyers also have access to tools tailored to their needs. For example, tools to help with will drafting or estate litigation. Collection agencies apparently are using AI to streamline their process so they can go after ever smaller amounts of debt. The general public ends up using things like ChatGPT or doing Google searches. They run into challenges like hallucinations. The problem is that they don't know how to double check to make sure the cases that they're finding are actual cases. Jurisdiction is also a big problem. They find information that does not apply to Manitoba, and they end up with inaccurate information, or they end up using forms from another jurisdiction. They perform searches using criteria that are too vague or too broad. Little ray of hope. One area that they seem to be having some success in is when they use AI to try to organize their arguments, organize their thoughts. And as I mentioned, the number of self-represented litigants will continue to grow. They'll continue to use AI because they have no other choice. So what do we do to help them? And there are a few things I've run across. People's Law School, which is a public legal education organization in BC, has developed a chatbot. It's a closed system, so all they're using is their own information, not just mining from the general internet. Canley's analyses, which can be a starting point for self-reps, and I noticed in the intro that they have webcasts on doing research. Some of the public legal education information groups are using AI to create plain language publications. Saskatchewan's Access to Legal Information Initiative has developed a fact sheet dealing with using AI tools to obtain legal information in a responsible kind of way. At CLIA, we'll continue to help self-reps through our law phone-in program. We have videos on doing legal research. And in the spring, we're hoping to host a webinar on tips when using AI to avoid the pitfalls. So thank you again for inviting me to be on the panel. And again, I will be more than happy to answer questions when we're done here.
And thank you very much, Mary. And our next and last speaker is Susie Dunn. Welcome.
Hi, everyone. Thank you so much for inviting me. So I've been invited to speak a bit of some of the risks that come up with using AI and some of the challenges and trends that show up. And some of them have been covered already. I think the one that people are most aware of is this concept of the AI hallucinated cases. There's a journalist who's been collecting these cases. His name's Damien Charlatan. And I'll post a link to his website on in the chat. And so far, he's identified 487 cases, published cases, where there's been some form of hallucinated case, and 36 of those have been in Canada. So this is cases where this type of thing is coming up, and people have actually used inaccurate cases or wrong cases or made up cases to try and rely on their arguments. So that is one of the biggest risks that we see in law, is that people just aren't relying on appropriate law. I think for a lot of self-represented litigants, I think when they're using AI tools, one of the challenges that they're going to have is not necessarily focusing on jurisdiction. So in the same way that a self-rep might go onto Reddit and say, I'm getting divorced. What do I do? How what are the rules for divorce? And someone might be replying and saying, oh, this is what I did in my circumstances, but maybe they're in Alaska or they're in an entirely different jurisdiction where the laws are incorrect. You can see that same type of faulty arguments showing up through various large language models, especially the broader ones like ChatGPT. The benefits of some AI is that we are starting to see more closed loop tools being created. So as lawyers, as self-represented litigants, I'm sure when you're looking online, you're getting a lot of products that are being advertised to you, and some of them are improving. Some of the LexisNexis AI is improving, the Canley summaries are improving, and you're starting to get these closed models that are based on a particular area of law. So Mary was talking about that using chatbots, but they're limited to really specific information, and those ones can be a bit more accurate. But we still have to be careful. So for example, even using paid products like the Lexis AI, studies out of Stanford have shown that they still have quite a high inaccuracy rating. And then in some cases with the summaries, like the Canley summaries, they might summarize one aspect of the legal issue in a case, but they might not summarize the other. And so the capacity to be able to double check is something that's critically important. And as Alicia was saying, this is a part of our legal duties as lawyers, is to go in and double check this content to see whether it's real or not, or whether the summaries are accurate or not, which can be a lot more difficult for self-represented litigants who might not be able to tell the difference between looking up a case on Canley that perhaps has been overturned or is outdated, and being able to figure out what the most relevant law is to date. If you're interested in reading more about AI and lawyering, I'd really recommend law articles by Amy Salazin, who's a professor at the University of Ottawa. She's published quite extensively on this. I'll post a link to one of her more recent articles where she was able to find 17 cases where self-represented litigants had used improper information in the documents that they were turning in. And the thing that's interesting, on 404 Media, which is a tech media site, they actually went and looked into some of the cases from the falsified case files, and we're looking at the reasons that people use them. And a lot of the reasons that people use these falsified cases is that they thought that ChatGPT was doing research for them, or LexisNexis was actually doing research for them. But as Dr. Salegi said, it really is just this word generator, so there's this level of inaccuracy. But even lawyers thought that they were doing research. And the other piece that you see is that a lot of lawyers are blaming it on their clerks or their assistants or whoever else it is. And we've even seen this in judicial cases. There was a case a few weeks ago out of Mississippi where a judge had his staff draft up an order for one of his cases, and it turned out that it was flawed because his staff were using ChatGPT. So having an understanding of who's using what technologies in your organization is something quite critical to be able to understand. The second challenge that comes up with using generative models to draft legal documents, for self-represented litigants, it can actually be a really helpful tool to make their writing more cohesive and be framed in a more legal style that they might not be familiar with. But when I was playing with ChatGPT, asking it, can you create an affidavit for a family law case where, one parent's trying to relocate to another place, and, gave me a draft for it. And then I said, can you change it so that there's evidence, that there's that one of the parents has an alcohol problem or has whatever other problem it was. And then it added in some information, but some of the information wasn't information that I had asked it to add. So it said there's documented evidence of, child abuse or whatever else there is. And so with self-represented litigants, in some cases, they might not even be trying to deceive the court. They might just accidentally not read over what the LLM has created for them and might accidentally submit false facts to the courts. So I think that there's a challenge without having that kind of human in the loop, that person to double check and reread all of the content to ensure that it's accurate, that I think we're going to see more mistakes both in the law that's being submitted, but also in the evidence and the facts that are being submitted. And then some of the other future challenges that are coming are a bit more complicated than that. So one is when self-reps are just using AI in kind of innovative ways that haven't been seen before. So there was a trial in the United States where there was someone who was struggling with speaking to the court. They were feeling self-conscious about the way they were speaking. And so they created an AI avatar to speak for them. And they presented this video to the court that represented the things that they wanted to say. And the judge stopped them and said, who's this person? Is this your lawyer? What is this person? And the self-rep, said, no, this is just my words, but I'm getting it spoken through AI. So I think people are going to bring kind of strange and unusual uses of AI. Another example was a case, it was a hit and run, and the family brought in a victim impact statement that was an AI avatar of the person who had been killed. So you have someone who's bringing in a false representation of a dead person, saying that it's a victim impact statement. And in that case there, the judge did rely on it. And they said, in the law, in that jurisdiction, you're allowed to bring in victim impact statements. You can have a poem, you can sing a song, you can do whatever you want. And this was just another way that the family was able to bring in evidence for the court. So I think courts and lawyers are going to have to be making decisions around what type of AI tools can be used. And we've seen cases where people have tried to rely on AI analysis, AI definitions. There was someone who tried to rely on a definition from ChatGPT rather than from something like the Oxford English Dictionary. So I think there will be challenges when either self-reps are coming in themselves, trying to bring in evidence that they've created using AI, or if you're on the other side, what do you do with that information that's coming in? Another challenge that's going to come in is just going to be falsified evidence that's created through AI. Dr. Salegi had mentioned the new Sora 2 app, which is an app where you can put your face and voice into it and and can make realistic videos of yourself. You can also give permission for other people to make videos of you. So you can imagine in a family situation where multiple people are using Sora 2 to make silly videos of their family, that technology could also be used to create evidence, both positive and negative, about a particular person that the courts are going to have to determine whether that evidence is real or not. We see this with voice replication, which voice cloning is a lot more convincing compared to visual AI at this moment. It's quite easy to create voice recordings, and then you can actually train different AI models to mimic the speech style of another person. So it's easier to create more realistic looking text threads or email messages that actually sound like they're from the person that they are. So these will be, issues that come up in digital evidence that'll be a challenge. But although it's less common that we've seen the introduction of AI evidence and falsified AI evidence, we are starting to see cases that deal with this issue of what's called the liar's dividend. This is a term that was coined by Bobby Chesney and Danielle Citron about deepfakes. And that the concept of the liar's dividend is that now that deepfakes are out there and we can falsify audio content, we can falsify video content, we can falsify images or text content. Now, when you're in court, someone can say, when you're submitting actual evidence that's real, the other side can say, that's fake, that's a deepfake. You need to prove to me that it's real. And so the courts are now going to have to deal with these issues when people are bringing in content that is real and is being challenged as deepfakes. What can you do with that? And then the final piece that I'll speak to before we go back to Q&A with the group is a bit on what Elisa was talking about the use of AI tools by law firms. And when law firms are using AI tools, they can be extremely beneficial. I was recently working with a group of family law lawyers, and we created this scenario to do kind of a mock cross-exam. And it drafted like a whole bunch of fake court documents for us. We asked for them to make them fake. We created a scenario, and then we asked the AI to create cross-exam questions that we could use. And it saved a massive amount of time for that particular project. And so those cost savings need to be passed down to the clients, because if your work is more efficient, that's something that the client shouldn't have to pay for. But on the flip side, this technology, some of it costs $50,000 a year to use. And so when you're deciding as a firm to adopt technology that you wouldn't necessarily have used in the past, how are you passing down the costs of actually using that technology? And again, even this high-end technology, this was a type of AI that's used in most of the major law firms, most of the Bay Street law firms. Even when we were using that tool, that it's expensive, it's well made, it's more accurate than other more free types of AI. There were still significant errors when we asked it to draft us cross-examination questions. It gave us confident lists of questions that we could use and reference back to where in the material it was. But there were several spots in that where you're not even using it for research, you're using it as kind of a thought support tool, that there were mistakes in it. So at all times, when lawyers are starting to rely on these tools, even to support writing client letters, to create cross-exam questions, and these types of things, you again always need to make sure that you have the human in the loop who's double checking those things, making sure it's referring back to actual statements in the documents to ensure accuracy. But I'll stop there, and then we can join back together for some questions and answers.
Hey, thank you very much, Susie. And kind of leading from your conversation, you talked about Sora 2 and being able to make silly videos and voices of other people. So for Elisa, from your presentation, can you give me some examples of how AI might reproduce bias or discrimination from the data that they have?
Sure, happy to, John. I understand that a number of, and I don't know about, I think some law firms, but certainly other organizations are using AI to help in the hiring process, to help vet applications. And some larger organizations might receive hundreds of applications for positions. So for example, if there's a big law firm that is looking to hire an associate in a particular area and they are receiving, hundreds of applications, they might use AI to help select the candidates that they are going to interview. And so what they would need to do is to train the AI tool so that it uses past hiring practices and the associated documents to kind of assist AI in knowing what it wants to look for. So it might feed in information or resumes from past hires who've been good hires. And let's just say that the firm historically has hired a majority of lawyers who attended one of two or three particular prestigious universities. So graduates from that university. And let's say that coincidentally, many of those graduates also happen to play a particular sport. Let's say it's hockey and the firm has a hockey team. And so they like to hire people who are good hockey players who can join their team. So if the firm is feeding in information about the people they've hired in the past, and the majority of people they've hired fall into certain categories, the AI will then look for people who have graduated from those same two or three prestigious universities and people who say they're hockey players. And it might be biased and look at those factors, which might not be what the firm is wanting it to look for, but if it isn't alive, if those inputting the information aren't alive and aware of that, it might that might be the result, which isn't necessarily the intended result, but it's an example of how AI can replicate bias or discrimination. In some cases, it's unintentional, right? If the users don't know to correct it. And then of course the effect is that you end up interviewing people who look very much like the people you've hired in the past, right? So this isn't helping to diversify the pool of associates that the firm was bringing on.
Yeah, thanks. And so, you talk about hockey teams and organizations. So we're not just talking law firms here, as I indicated earlier. So I think maybe just highlighting that for other organizations that might be online, that we're not just talking about the Law Society and lawyers here.
Absolutely. That would be true in any setting, right? If the same propensity or sort of risk of replicating bias and discrimination would apply if you use the tool and you aren't sort of live to those factors.
Okay, thank you. So my next question is for Katie. There's been a rush to introduce automated decision-making systems into the administrative state, usually citing efficiency and impartiality as drivers. Can you talk about some of the ethical concerns that arise in this context?
Great question, John. Thank you. So it's really interesting, right? I think as we consider how generative AI is being used in more context, we also see traditional kinds of AI that are being rolled out in any area where people are likely to be making decisions. And some of the same types of issues are going to come up in both of these situations. A big one is the idea of what is the data set that is being relied upon in order to make those decisions. So are you able to have confidence that you have a data set that's going to be free from bias and discrimination, that you're going to be able to sort of prune undesirable information, or are you going to end up replicating historical legacies when you use those kind of automated decisions? So in the administrative state, we see uses of automation in situations that are traditionally in low rights environments, right? Places where people would have been interacting with a human decision maker, and it can be costly to have people filling those roles. And so they can be often the first line of defense when people are replaced with a machine analog that is able to make those kinds of decisions for them. And then when we add on an additional layer of generative AI, we can see similar types of issues arising, right? This idea that now instead of talking to a human, you're interacting with a chatbot when you make decisions. And are you going to be able to rely on the training of the data set, the type of information that it's able to call up when it is asked a question, and whether there's going to be hallucinations and some of the different issues that we've already discussed, right? So really interesting example of this last year was the Moffat and Air Canada case, which was a decision of the BC Civil Resolution Tribunal, where a young man named Jake Moffat wanted to attend the funeral of his late grandmother, and had reached out to Air Canada for information about bereavement fares, and had assumed that the information that he received from the Air Canada chatbot was accurate, acted on that information, only to later be told that, oh, the information from the chatbot was completely fabricated, and information otherwise on the website, hidden under many, many different menus, would have called that information into disrepute, right? So what does it mean to have that reliance relationship when you're interacting with someone in an administrative context? I think it goes to what Mary was saying earlier about that idea of access to justice not being only about being able to access lawyers or only being able to access courts, but what are the other ways in which people are interacting with the judicial system or sort of the vestiges of law in their daily lives. Many people, the first point of contact that they will have with the legal system is with the administrative state. And so what does that look like for how decisions get made? I could go on, but perhaps I'll stop at this point.
Well, maybe I'll have you carry on. So you talked about the case where if you dug down 16 layers, you might find the correct answer, which isn't something people normally have to do. So what do you think people should know now that they probably didn't even think about before, didn't have to know before interacting with AI?
One of the things I like to highlight is the risk of automation bias that turns up when people interact with any kind of automated system. And so we have really strong research from human computer interaction or human automation interaction spaces that shows how people tend to kind of turn off their brains when they're interacting with an automated system. And so they think, oh, the automation probably has it right. I'm just going to let it take the reins here. I'm going to let it make those types of decisions for me. And this introduces twin phenomena of both automation bias, right? Thinking the automation knows better than you, and automation complacency of allowing the automation to drive while the human reasoning takes a backseat in that type of situation. And so that's something that I think we all need to be on the lookout for when interacting with automated systems. And in particular, in situations where you have lawyers exercising skill and judgment, monitoring the work product that is being done, right? Like we mentioned the cases from situations where people, oh, I didn't know that somebody in my firm was using this type of information, or that wouldn't be typical practice, right? It's very easy for it to creep in to the normal practice and for us to become complacent about the type of work product that is produced, especially when it's usually right. Right? It can be really, really accurate some of the time and then produce something that's totally out of left field. Last year, I was in Montreal presenting to the Employment Lawyers Association, the ELA, great group of folks. And we did a live demonstration of ChatGPT asking employment law questions. And we had a group of both Canadian and American lawyers in the room. And we were able to ask it, okay, what are the key cases for distinguishing between an independent contractor and an employee, right? Some of your bread and butter employment law questions. And it was able to give us some cases from the American context first when we didn't specify jurisdiction. And all 4 of them were real, right? And 2 of them were even on point. And the other 2 at least were still employment law cases, but they weren't quite germane to the question that was asked. And then we said, okay, can you also give us some Canadian cases? And the Canadian cases, right, they give the case about the Bardell factors, and they give Witten and public-private insurance, like pilot insurance, almost right, maybe not quite what it's about. And then they give 2 cases that the style of cause looks quite convincing. It's a numbered company versus a government department, right? Two instances of that. Got numbered company versus Canada Ministry of Transportation, numbered company versus BC Attorney General, right? Totally plausible that those would be styles of cause in an employment law case. And probably the bot had seen many, many examples of cases that were formatted in that way. But both of these cases were hallucinations. And what I thought was particularly nefarious about that is they were produced after you'd seen a whole bunch of real cases, right? So even if you checked the first 6 cases, felt pretty confident that they were right, and then didn't check case 6 and 7, or 7 and 8, well, those were the 2 that were hallucinated, right? And so those are the kinds of problems that can start to creep in.
Can I just jump in, John, and add something to what Katie has just said? I think it was Susie who mentioned Amy Salazan's wonderful articles, and I just read one this morning, actually, that sort of dovetails a bit on what you just said, Katie. She talked about the fact that, like, it's not just entire cases that might be hallucinated. It might be the test that the court sets out in a case that AI might get 2/3 of the test correct, but one of the heads set out in the test might be incorrect. And so just as you say, when we have to look out for those more subtle errors or hallucinations, not necessarily just the entire case, but it might get like 90% of what the case stands for correct. And then there just might be a few mistakes that if we're not really attuned to, we might miss as lawyers, and certainly, as members of the public attempting to navigate legal research as well. So I thought I would just add that in.
Absolutely.
Well, thank you for the comment. So, when we talk about the duty to make sure the information is accurate, whether that's to the court or your supervisor or the supervisor checking to make sure the information they get is correct. My question is for Mary, and given what you know about self-represented or unrepresented litigants, probably using AI because they have no other choice, how do you or how do we help them avoid these AI pitfalls that we've heard about?
I think primarily educating them as much as we can about the pitfalls, about what to look for, about alternatives for them. I mentioned some of the types of projects that seem to be quite successful. For example, in BC, the chatbot. That's all sort of early stages, though, and I think quite expensive. So I'm looking very, with a lot of interest in how that's going to turn out. It seems like they've been doing some studies on that, how well the accuracy is, and also how well people are responding to it. But I think primarily to give them as much information as possible. The problem is that we don't get them beforehand. They don't come to us and say, well, I'm thinking about doing some research. They come to us after the fact. So it's quite often a little difficult to give them that information, but I think that's the keys: as much information, as much as education as possible, so they understand what they're looking for and what they need to avoid.
Hey, thank you, Mary. So maybe I'll, just looking at the time, I'll have one more question for Susie, and then we'll ask some questions from our audience. And in that regard, just a reminder to the audience, if you have any questions, use the Q&A section for your question. So Susie, where do you think the benefits or risks of AI are over, the underhyped in relation to access to justice? Like, do you think lawyers are going to be replaced? Is AI always wrong and untrustworthy? Give us your kind of perspective.
Yeah, I think we really need to balance this, right? Because I think that there is a little bit of an overhyping in some spaces and a little bit of an underhyping in other spaces. Like I was just quickly glancing at some of the questions from the Q&A, and there's some factors that we're not necessarily taking into consideration, right? They're like, this is going to be fabulous. It's going to make the world so much better. But there's things like the amount of energy consumption that it takes to do an AI query versus doing a regular query, right? Like the technology uses thousands and thousands and thousands of liters of water and so much energy. So I think that there's like interesting ethical questions we can ask ourselves. But I think some of the challenges of the overhyping is that I think law firms are going to start adopting AI tools, thinking that it's going to really help them solve a lot of problems. Because I think that the example that Katie gave was great, right? Where if you look at it initially, it's like, wow, like, why do I have an assistant? Like, why do I have an articling clerk? Like, I don't need these people. I've got my AI. And we've seen this happen in other areas, not in law, but for example, they switched I believe it was an eating disorder call-in helpline. And they're like, well, this is great. We can just use a chatbot. So they like got rid of all their volunteers. But in the end, what they realized was that there was a certain level of experience, there was a certain level of human touch that people still really wanted. Like even if the content was accurate, which unfortunately in that case it wasn't always, there is still this necessity of the human touch. And then I think the way that it's over exaggerated in that like AI is going to ruin everything. If you use it, you're going to, get your bar license taken away. You're going to get in trouble. You're going to embarrass yourself. I think some of that language makes it really difficult for lawyers and law students, which is more my experience comes from, to be able to talk really frankly about what their uses are right now and what's actually helpful and what's not. Because I think some people are secretly using it and not telling people about it. And because we're not having conversations about the reality of AI, this is when people get trapped in these accidental issues where maybe they're using an AI program where their data from that query is actually being transferred to a server in a jurisdiction, sometimes in a different country where like different laws apply, where I think we need to be having more conversations realistically about how much do these cost? Are they actually helpful? Is it actually more efficient? There's this assumption that they are more efficient. And where is it that we can use it that's helpful or not? There's a really fabulous quote out there about AI where this artist says, I want the AI to do my laundry and my dishes so that I can do my art. Like I don't want AI to do my art so that I have to do the dishes, and I think it's the same thing in law. We have to realize what are the kind of basic tedious tasks that we can pass on to AI that allow us to do the deeper thinking about the ways that we want law to advance, the ways that we can save a little bit of that time that we might have spent, drafting or digging through documents to have more human contact with our clients to provide them with better services. So I think when we're thinking about AI, we have to be careful not to, talk about it like it's this god that's going to, remove the whole legal system, but also not necessarily talk about it as though it's going to destroy everything and always be problematic.
Okay, thank you very much. So I'm actually going to turn to some of the questions in our Q&A now. And I think my first one's going to be for Alyssa, because you did bring up about the Law Society and noticing that you're using Adobe products that has an AI program running in the background. So the question is, are you going to send out anything to the bar just to let them know and what to watch for, or just give them some awareness?
Thanks for that question, Don. That's a great question. So our AI guidelines were the starting point, but we absolutely expect and plan to send out further guidance. I'll be completely honest, it's something we're figuring out internally, right? As I mentioned, these things are changing so quickly, and that discovery for us about the Adobe product was quite recent. So we're sort of having a look at our internal policies, and we've certainly talked about the fact that we at some point there's a need and it would be beneficial to provide some further guidance to the profession. So that is something I expect we will look to do in the not too distant future.
Good, thank you. And the next question is actually directed to Professor Dunn or anybody else that wants to jump in after that. So the question is, with respect to potential allegations of generated evidence in court and the potential for parties to have to prove their evidence is real, how do you see judges dealing with that type of allegation? A motion where a party has to prove the evidence is real, perhaps, or will parties have to provide some sort of identifying information when providing evidence, basically authenticating the information that's being presented?
Yeah, so I think there's going to be a mix. In the two cases that I've read, which are both criminal law cases, they were able to use circumstantial evidence, to do comparisons of copies of the videos, to be able to look at other circumstantial evidence, time of day, what people were wearing, this type of thing, in order to show that the content was actually what it said it was. But I do think that lawyers are going to need to get better at looking at things like metadata on digital documents. So being able to look at, photographs or videos to look for timestamps, what IP address emails are coming from, in order to provide additional information that would support whether the evidence is real or not. And I think in more complex cases, it might lead to the point where expert evidence might be required, which is something that I think is a real challenge when we're thinking about cases, particularly those with self reps who might, they might not be able to even afford a lawyer. Like, how can we expect a self rep to bring in an AI expert to be able to determine whether a video is falsified or not? But for example, in edited text messages, where someone is submitting a set of text messages, the court, the other side may need to find the person. I'm thinking family law mostly, so it's like you've got one spouse who says, here's these messages that have been sent to me. You might need to go to the other person's phone and provide that same set of text messages to show where there's discrepancies or changes, or that they didn't exist at all, where they can say, my ex-spouse didn't send me any messages on Tuesday. Look at my phone, look at my evidence. If you look at the metadata of my text messages, you can see I haven't deleted anything. Nothing's been removed or altered. But I do think in some circumstances, if they're not able to get around that circumstantial evidence piece, that at sometimes it's going to require expert evidence. And judges themselves are struggling. I do these presentations for judges, and I was at a conference with judges recently, and one of the judges put their hand in the air and they were like, what's metadata? And so that's a problem. I think there's a need for judicial education on some of these more technical terms, on understanding what underlying data on digital artifacts and digital evidence that are being submitted as evidence for both lawyers and judges, in order to determine the authenticity of evidence.
Great. And my next question is going to Katie. So if you wanted to add on to that answer, great. But here's the question, because I know you speak several or understand several different languages. So for anyone that's able to speak or use AI for translating self-reps or otherwise from English to a second language or back, is there anything that the legal profession or professionals should be aware or cautious of?
That's great. I think that might be one of the few applications that I have less concerns about, as long as we can verify that it's a relatively good translation. I mean, maybe it doesn't put translators out of a job just yet. If we have someone who's able to verify, like spot check, that the translation is effective. But I do think that in terms of an access to justice issue, finding people who are readily available to communicate with people about their legal rights continues to be a really thorny problem, especially when you have people from significantly linguistic minorities where they don't necessarily have a lot of people around who are able to speak their language and communicate things to them in a way that they can understand. I mean, again, you'd have some of the same equity issues, I think, pop up in this context too, where most of the generative AI is really good at English, right? Because that is what the Silicon Valley moguls who are excited about this tech speak, and that is sort of the dominant language of commerce globally, for better or worse. And so when we're talking about ChatGPT, Gen AI, LLMs, we are mostly talking about large repositories of the English language. So do we have the same amount of examples of minority languages that these models are going to be able to learn from in order to make them effective? And the answer, I mean, so far is no, except for maybe some of the bigger European languages that have bigger examples are starting to build LLMs too. But I do think that this could be an application of the technology that could be harnessed for good.
Okay, thank you very much. We're actually going to go back to Elisa. There's a couple of questions here that are very Law Society-like. So one of them is just about where maybe a client doesn't trust you because they've done their own AI search and they have different opinions and recommendations than what you're giving them because they're getting their advice from AI. Would you perhaps see that as something justifying the withdrawal of representation under the code?
Well, I guess that depends. I mean, I think first it would warrant a conversation, right, with the client to maybe ask them a little bit about where they got their information from, explain the limitations of AI, again, share your opinion. But I suppose if the client was very attached to whatever it was that they found and wasn't prepared to engage in a discussion or to hear you out or be swayed, it could lead to a breakdown of trust, of confidence, and it might lead to that. I'm sure that's something, maybe we could look to the medical profession, because I think with Dr. Google, doctors have probably been dealing with that for a while. But I would hope that, clients have to have a certain amount of trust in their lawyers, and I don't think it's unreasonable. People now have access to all kinds of information, and I think increasingly the public is educated about the law. So, I think it wouldn't be unusual that clients might come to their lawyer and say, well, what about X, Y, and Z? And, hopefully there could be an exchange and the lawyer could explain, the reason for the position they're taking or the advice they're providing. And they could resolve it that way without it leading to a breakdown in the relationship and a need to withdraw.
Hey, thank you. I'll field this to Katie, but Susie, feel to jump in after. But we talked about being careful about what information you use in your searches or inquiries with AI, because it may be used to train the AI model. So the question is there a closed loop AI chatbot bot that you could be used in-house, where you're not worried about your data set going out to the world at large?
Yeah, so there isn't one that I can recommend off the shelf or anything like that, but there are people who are trying to create these kinds of solutions. So sometimes you will hear that people have built an in-house version of an LLM. And so what they mean by that is they've taken this GPT technology, and this stuff is readily available. It's open source, more or less, right? A lot of the early papers that describe the technology that OpenAI was developing are all published on arXiv. It's ARXIV. It's the like computer science and engineering paper repository that's maintained by Cornell. And on there, you can find a lot of the chief innovations. And yes, there's going to be differences in how the models work between the major proprietors on the market, but the chief innovation of how a GPT model works is the same pretty much across the board. Right? So some people are saying, yes, we're going to create in-house versions of this technology using the transformer technology that say it's only going to read legal cases. We're going to download everything from Canly. We're going to put all of that text into a database, and we're going to train it specifically on legal cases so that it is a purpose-built tool for that system. We're going to have an in-house server, and that server is going to be housed right within Canada, subject to Canadian data protection and privacy laws. We're going to make sure that the server is secure, so we're not uploading sensitive client information to the cloud or to a server that is housed in the US, kind of creating cross-border privacy issues and potential cybersecurity risks. And then what happens down the line, hopefully, is that you're able to build these types of systems that can be really successful within a specific law firm environment. And you're going to train the model to be really good at answering the types of inquiries. So for example, when I was, again, to that ELA conference I attended last year, there were some European partners that had done one of these in-house, and it had been so successful that they had spun it off into its own corporation, right? So they could clear conflicts. And then they were selling that as a service to other law firms. And you will see that growing more and more. I mean, we talked about it a little, but there is a huge amount of innovation and investment right now in the legal tech industry in particular. So I'm on all these legal innovation mailing lists, and they're always telling you huge amounts of private corporate investment, and it's going to transform the legal industry, and so on and so forth. I mean, I don't think we all need to be pulling down our shingles just yet, because I think we probably have a little ways to go in terms of how effective this technology is, but there is a lot of excitement about it. One of the things you'll also hear when people talk about these kind of solutions is that they're able to get rid of hallucinations because of how they've trained the model to be really specific for these legal purposes. Oh, we're not using, ChatGPT or Anthropic's Claude or one of these general ones. We have a special one that we're building just for our firm, and it's really good at doing the kind of work that our firm does. And this is true to a point, but what they're actually doing in these kind of solutions is another programmatic innovation that's called retrieval augmented generation, or RAG, which means that they're adding other kind of computer science innovations and appending them to the way that the transformer model works within the GPT structure. So it's almost like a scaffolded solution, right? Remember earlier I was talking about the strawberry problem and how that's like fundamentally this is an issue because of the way that tokenization works, right? When you have a string of text that's being parsed by a transformer, it's going to cut it up into tokens. And so it cannot count the number of R's in the word strawberry because it doesn't interact with the word strawberry as strawberry. And modern GPTs have solved this. They haven't really solved it. They just have one of these retrieval augmented generation techniques scaffolded onto it so that if someone asks that question, they get the correct response because the programmers have said, oh, it's a problem if people see it this way, right? It's a similar issue. There was there was an unfortunate blunder a couple of years ago where Google image search results was tagging people with darker skin, particularly African American people, as gorillas in the search results. And this was obviously an equity issue. People were very upset about it. And so in order to respond to the situation, what did they do? They just made it so that no images were tagged as gorillas. So even if you were trying to find an image of a gorilla, you wouldn't be able to. And so, yes, you don't find the undesirable result, but the fix that's happening on the back end doesn't fix the actual problem that you're trying to solve. And so that's often what happens in this context when people are talking about, oh, we've solved for hallucinations. It's like, well, no, you haven't, because hallucinations are a feature, not a bug. They're fundamental to the way that large language models work in terms of having that variable temperature, having a degree of creativity in being able to come up with a response that is going to be interesting and responsive and mimic the way that people engage in human communication. But do we have other programmatic comp sci things that we can do to append to it to make it more likely that it's going to be right? Right? And sometimes now we're seeing these different Gen AI research tools that are providing links to where they got the information. So that's an example of that, right? Where you're able to say, oh, look, I can find my sources, and my sources are able to be connected, at least somewhat rationally, to the prose that was connected. That's not really how the prose is being generated, but it is enough to create that linkage to make it seem more like it's research, if that makes sense.
Susie, I see you're online. They're very much along the same lines and maybe carrying on from what Katie has said. Do you see that with enough material and enough research, and we're only a couple of years into this generative AI online that people are using, do we see that at some point I'm going to trust that it's not going to have hallucinations, just like when I do a search on Lexis or Westlaw, I get the case that I want and I do not have to go any further in my research. What do you think? That we'll get to that point?
I think you trust it as much as you trust your articling students, right? Like if you've got a really good articling student who's been producing like really good information, you know, you're more likely to rely on their content, but you still have to double check it. And same thing, like if you've got an articling student that isn't as reliable, you know, but either way, even if you're using an AI tool, like we have legal obligations to always double check every single case that we're relying on. But I do think the technology is going to improve. And just specifically on the comment about like what tech to use, the Law and Technology Institute at Dalhousie did a CPD session on AI in the practice of law. And so there's some videos online there where there's actually legal practitioners who are talking about, you know, some of the types of technologies that they've been using and the kind of benefits and drawbacks of that. Most of the technology that I find lawyers are relying on is more for drafting than it is for research. The drafting tools for AI have been a lot more helpful. So people are using things like Harvey AI and CoCounsel and Copilot and these types of technologies. And the research tools have been interesting, but so far I haven't heard of lawyers really overly relying on them for research as significantly as they are for drafting. That seems to be where the effectiveness is. But I do think we will eventually get to closed model systems that are quite helpful. But again, that professional responsibility we have is even if they are 99% effective, 99% accurate, there's still going to be that 1% piece out there. So we always have to double check our work.
Thank you. I have another question for Lisa. There's actually a couple here, but one deals again with your AI and Adobe comment and the concern just about scanning documents into PDF and then emailing to yourself. Is that in the outside loop? Is that something that's out there that may get brought in to the AI world, or would we call that a closed loop?
It's an excellent question, and we have that same question, and we're looking into it now. So, and that's the point I make. I did have a conversation with somebody in our IT department about that recently, and there was a little more to it than met the eye. So I unfortunately don't have the answer for you at this time, but that's certainly something we're looking at because we had that exact same question. And I think, right, that's not the first program or application that we used where we found that AI is just suddenly being embedded and has appeared without much fanfare or notice. So I think this is something we all need to kind of think about, and reading terms of service is sort of a great place to start. As I said, I expect at some point we will likely look at providing some additional advice of some kind or further guidelines to the profession. But frankly, we're sort of working our way through that a bit now ourselves. I'm sorry I don't have a better answer for you. Somebody else might might be able to add to that.
We'll watch for the release from the Law Society in your monthly newsletter for updates. I know we're getting near the end, so Mary, I haven't really had any questions for you, so I'll just ask you what you see as one of the biggest challenges with community legal education and what they face on self-represented litigants and the general public and what they're using with AI.
Okay, thank you very much. And now I have a terminology I can use for this, automation bias and automation complacency. Thank you to Katie. Quite frankly, that's what we're running into. As I said before, we don't get people calling us before the fact that they're going to be involved in a case or they're going to be doing some research. They call us when they're already deeply involved quite often. And they will have found something, they will have done a search of some sort that doesn't take into account jurisdiction. They get information. They come to us. I'm not quite sure why they're coming to us when they already have the information, but maybe they just wanted to verify that it is correct. So we tell them, well, no, that's not correct because of jurisdiction or whatever the reason is. But they get very adamant that it is correct. So that's probably the biggest challenge we're facing, is that people are doing their own research. They're taking it at face value. They're not really doing because they don't really know about doing that, about checking into the actual cases or actually looking at the legislation. And again, I think it points to having to do an awful lot more education in terms of having people, and that's going to be, again, hard to do because they do their search. They don't even get to a website. It's right, the information's right there for them. So they don't have to go further, and quite often they don't. So that's kind of the biggest challenge we're facing, is trying to get that information out to them.
Thank you very much. And that actually brings us to the end of our session. So sorry I wasn't able to get to the last few questions that were in the chat. But before we are done, I do see that Susie has posted a number of really useful links. So before the webinar ends, those that are interested might want to make a copy of those. So thank you very much for everybody attending today's conference on AI and access to justice. The presentation will be posted on the Manitoba Access to Justice website, which is the same place you use to register for the webinar. That includes the slides as well. And we'll also send out a feedback survey to everybody that signed up, and we hope that you'll complete it. Let us know what you learned from the topic, or anything you'd like to hear additionally from the Law Society in doing these types of presentations.